Hi, I'm with Jeremy Swanson here, and we're here to talk about restraining orders. And it's very common that a client will come in and say, hey, I've been hit with a restraining order. What do I do? I guess preliminary, what is a restraining order? What's the effect of it?
Restraining order is a filing in a civil court asking for specific orders like no contact orders or move out orders or non-harassment orders. And they are initially filed as temporary orders, and then you get a hearing where the judge will determine whether the orders are appropriate or not.
Okay. And so let's say someone's hit with a temporary restraining order right off the bat. What should they do?
Well, the first thing you need to do is you need to read the restraining order, because the restraining order will have specific terms in it. And in the restraining order form, for every request that the party who filed the restraining order makes, the judge will either grant or deny that order. So you need to read your order so that you know what the terms are to make sure that you don't violate them. The second thing that you need to do is you need to make sure that there's no criminal case that's connected to the restraining order. Oftentimes, you will have a restraining order filing that comes out of some sort of an incident where law enforcement is called and reports are made. And particularly if there's been an arrest of any kind, you need to make sure that you don't have any criminal proceedings against you.
So would that be something like a domestic dispute or some sort of physical altercation?
That's correct. It generally will be a domestic violence type of case, or it will be a assault and battery kind of situation. And in either of those, there can be criminal charges filed, and you need to make sure that there aren't. And the reason for that is you can have evidence that comes out in a restraining order hearing that can be used against you in a criminal filing, which is obviously much more serious. So you need to make sure that you're not providing ammunition for a criminal prosecution.
Okay. And so let's say someone, well, how important is it for someone to have an attorney if they do have something like this filed against them?
It becomes very crucial in certain circumstances. One is if there is a criminal filing, you really need to have an attorney to make sure that your rights are fully protected. And the other situation is where you have any kind of an employment situation where you could lose your job or career advancement, anything like that where a background check is used. A restraining order will show up on a background check and can influence that. Most employers check for those. So that's the kind of issue where you would need to have an attorney. The other time when you would need it is if the evidence is at all complicated, meaning there are multiple witnesses, there are text messages or pictures or phone records or anything of that nature that you need to enter into evidence. That's when you should really consider having an attorney.
Okay. And then just kind of sum up, what is the best approach you think someone should take if this happens?
Well, after determining whether or not there are criminal consequences and what the temporary orders are, you need to begin preparing your defense. And in order to do that, you need to make a list of witnesses that have knowledge of events. You need to make a list of evidence that you would like to present in your defense. Many times that evidence needs to be subpoenaed. It's often phone records, it's often text records, it's often social media postings that need to be entered into evidence. So if you have issues where you need to subpoena documents from a company, then that needs to be done right away so that you have those. It can always be difficult dealing with large corporations such as AT&T, Verizon, phone companies like that. So you need to get that started right away to make sure that you have your evidence ready by the time of hearing.
Yeah, because that can take quite a while. It's a 20-day minimum. Sometimes it goes 30 days. If it requires a hearing, additional time. So every minute counts, really. That's
correct. And restraining orders happen in a very short period of time. Generally, from the time the temporary is submitted to the hearing date, you're usually about 15 days. However, judges will give you extra time to get prepared. So if you have things that you need to subpoena, do it right away and bring copies of the subpoena to show the judge, and the judge will give you time to get the full information in and gather the evidence that you need for the hearing.
Okay. Well, thank you very much.